I'm Elizabeth Cosenza, Associate Professor of Business Law and Associate Dean of Undergraduate Studies. For most of my academic career, my research has focused primarily on the interpretation of federal securities laws. Currently, I am participating in an amicus brief in the ongoing Goldman Sachs litigation. The crux of the legal issue that we are seeking the Second Circuit Court of Appeals to review is the showing that plaintiffs must make at the class certification stage. Companies often make statements in their public disclosures such as, "We behave ethically," or "We adhere to the highest standards of integrity in our business practices." Those are generic statements that you often see in a company's code of conduct. Let's say that 2 years later, the company is alleged to have engaged in some wrongdoing, such as price fixing. There's no debate that the government or the aggrieved party or parties should have some sort of redress against the company should the alleged wrongdoing be proven to have occurred. The legal issue that remains is whether investors in the company should be able to bring a securities fraud class action lawsuit based on an initial generic statement made by the company in its public disclosure, such as, "We behave ethically and adhere to the highest standards of integrity in our business practices." Class certification is the most critical stage in the life cycle of a securities class action lawsuit. Once a plaintiff class is certified, there is tremendous pressure on defendants to settle the case due to the unpredictability of jury outcomes and the often astronomically high jury awards. What I've been doing is looking at the body of case law on class certification across the country, across the district courts, the appellate courts, and the Supreme Court. What is ultimately needed is a very clear standard articulated by the court that sets forth the proof that plaintiffs must show at the class certification stage to demonstrate that the alleged misstatement had an adverse impact on the company's stock price. Ultimately, the decision that the court makes is critically important because it impacts companies, it impacts investors, and it impacts how companies will actually phrase their codes of conduct going forward. The outcome of this case will determine the financial loss that Goldman will incur in connection with the litigation. If the class is certified, there is tremendous pressure to settle quickly. If the class is not certified, the financial implications for Goldman would be reduced. If there were a clearer standard for companies, it would help to reduce the unpredictability of these types of cases. My colleagues on these amicus briefs are professors from Stanford, Harvard, Rutgers, Hofstra. We also have former SEC officials, so it's wonderful to be able to collaborate with others in the scholarly community and also those who have had significant industry experience and understand the enforcement landscape. And I think it's critical for Fordham to be involved in this type of research because it's industry relevant. The decisions that are being rendered by the appellate courts and by the Supreme Court on securities fraud are decisions that securities law practitioners are watching, that the legal profession is watching generally, and that companies, of course, are monitoring because it affects their day-to-day business.